Hello everyone, welcome to Lazy Law. Let's begin with new questions on Bnss. So our first question is 301 question number. A proclamation under section 84 of Bnss can be issued against a person against whom a warrant has been issued. Thus, a proclamation can be issued against option A is correct, accused offender. Next question. A criminal court issuing a proclamation requiring a person to appear at a specified time and place on basis of reasons to believe that he is absconding or concealing himself so that a warrant of arrest issued against him cannot be executed may simultaneously order the attachment of any property belonging to such person if it is satisfied that the person is about to first point dispose of the whole or part of his property, second point remove the whole part or a part of his property from the local jurisdiction of the court. So either condition 1 or second mentioned above must exist, so option B is correct. Next question. A valid proclamation under section 84 of Bnss 2023 requires public reading of proclamation in conspicuous place of town or village where the accused ordinarily resides. So option A is correct. When court issues a warrant for the arrest of suspected person, it must ensure the number of sureties, the amount in which the sureties are bound, the time and date at which accused person is required to attend. Here all options are correct, so option D is correct. All of the above. Next question. In case of suspect concealing himself to avoid arrest, the court can issue attachment, proclamation, and order publication of warrant. So here option B is correct, order of proclamation. Next question. A proclamation requiring a person appear must be published giving not less than 30 days time to the person concerned. Next question. Attachment of the property of the person absconding can be issued simultaneously with the issue of proclamation under section 84 of the BNS. Option C is correct. Period of limitation for filing claims and objections to the attachment of any property attached under section 85 of the BNSS by any person other than the proclaimed person as provided under 87 of BNSS within the 6 months of attachment. So option B is correct. Under 86 of BNSS, identification and attachment of a property of proclaimed person should be on return request to the court by a police officer not below the rank of SP or Commissioner of Police. The period of limitation for filing a suit to establish the right over the property attached by a person other than the person proclaimed who has been filed claims and objections to attachment is 1 year from the date of disallowing the claim. Next question. If the person proclaimed appears within the period specified in the proclamation, the property attached, so the option B is correct, shall be released from the attachment. If the proclaimed person does not appear within the time specified the proclamation, the property under attachment shall not be sold until the expiry of 6 months from the date of attachment, shall not be sold until any claim or objection made under 87 has been disposed of. So option C is correct, both A and B. Next question. A proclaimed person whose property has been attached can claim the property. The sale proceeds on appearance within 2 years of attachment. Section 90 of BNSS authorizes issuance of warrant in lieu of summons in addition to summons. So option C is correct, both A and B. Which of the following is false of a section 83 of Bnss? The word shall is subsection is dietary and not mandatory. Next question, which section of Bnss states that a warrant issued by Magistrate of India may be executed at any place in India? So here option C is correct, section 79 states that a warrant issued by Magistrate of India may be executed at any place in India. Next question, which of the following statement hold true proclamation made under section 84? So the magistrate issuing the proclamation must record his satisfaction that the accused has absconded or concealed himself. Next option, it is possible to issue warrant and proclamation simultaneously. Next question, a person who has left India before the issue of a warrant of arrest because he anticipated the warrant can be regarded absconded. And another option is even an absence of 1 day can be termed as absconding. So here option A is correct, that the magistrate is issuing the proclamation must record his satisfaction that accused has absconded or concealed himself. So next question is, under the Bnss, warrant can be issued in lieu of or in addition to summons. So here option B is correct, the court believes that the person summoned has been absconded. Question number 319, dash of Bnss deals with summons to produce documents or things. So here option C is correct, section 94. Which of the following is true of subsection 3 of section 88 of Bnss? So here option C is correct, it is enough to show that within that period the accused person appeared voluntarily or was apprehended or brought before the court. Question number 321, which of the following is false of subsection 3 of the section 88 of the Bnss? So option A is, it prescribes a remedy where is a good and legal publication but offers no facility for contesting the legality of the proclamation. Option B is, it contemplates and requires proof that the offender did not abscond or conceal himself to avoid arrest and that he had no such notice to the proclamation as to enable him to attend within the time specified. Other options are, it is enough to show that within the period of the accused person appeared voluntarily or was apprehended or brought before the court. So here option D is correct, option A and B, that it prescribes a remedy where is a good and legal publication that but offers no facility for contesting the legality of the proclamation. Then option is, it contemplates and requires proof that the offender did not abscond or conceal himself to avoid arrest and that he had no such notice of the proclamation as enable himself to attend within the time specified. The Bnss under section 84 provides ample powers to execute a warrant. However, if a warrant remains unexecuted, the remedy is issuing the proclamation, attachment and sale of the property. So option C is correct, both B and A. Next question, which one of the following is true in subsection 3 of section 84 of the Bnss? So here option D is correct, it makes proclamation equivalent to notice to the public of its content. Next question, what is the criminal jurisprudence of the country under which the Bnss conferred to the hierarchy of the courts specific powers to deal with the matters as may seem to be just and power? So here option B is correct, a person is innocent and the burden rests on the prosecution to prove beyond all reasonable doubts as regards the guilt of the accused person. So next question is which one of the following is true? Section 84. So option B is correct. Mention of the lesser period that required under the section will make proclamation ineffective, and that effect is not curable under section 511 of Bnss. Next question. When any person who is bound by any bond taken under this Suraksha Sanhita to appear before court does not appear, so none of the above is given. So option D is correct. Next question. Which one of the following is falls under section 88 of the Bnss? Let me read the options. Option A is this section penalizes a person who seeks to avoid his arrest under a warrant and against whom a proclamation is issued under 85. Next option, for disobedience of a proclamation he incurs liability to be punished under section 174 of the Bnss. This section put additional pressure upon the absconder by depriving him of his property to compel to obedience. Next option is it deals with the rights of a person other than the proclaimed of a person in the property attached. So option D is correct. Next question, in section 87 of Bnss, every claim or objection shall be inquired into the court in which it is preferred or made, provided that. So here option B is correct. If it is preferred or made in the court of the CJM, Chief Judicial Magistrate, he may make it over for disposal to any magistrate subordinate to him. Next question. If the property of the absconder is attached under section 88 of the Bnss, the minor children of the absconder are entitled to maintenance from him. Option A is correct. Cannot apply for the release of the property. Next question. When any person who is bound by any bond taken under Suraksha Sanhita to appear before court does not appear, so option A is correct. The officer presiding in such court may issue a warrant directing that such person may be arrested and produced before him. Next question. Warrant directed to a police officer for execution outside the jurisdiction is covered under section 81, so option A is correct. Of the three clauses of subsection 2(1) of section 84 of Bnss, clause A, B and C are conjunctive and not disconjunctive. So option D is correct. Next question. What do you understand by the word presence under Bnss of 2023? So a police officer may arrest without a warrant when a public offence is committed in his presence. Next question. Procedure by magistrate before whom a person against whom a warrant has been issued is arrested and is brought is mentioned under section 83 of the Bnss. An arrest warrant is issued by a court can be executed at any place in India. Next question. An arrest warrant in criminal case shall be signed by presiding officer of the court. So option C is correct. A warrant of arrest. Next question. A warrant of arrest is a command and should be in writing, must be signed, sealed and issued by magistrate, addressed to a police officer. So here all options are correct, so option D is correct, all the above. A warrant of arrest may be extended at any place within the India, so option B is correct. What does the expression transmit remand denote? So option C is correct. It is taking out an accused by police from one state to another state. Next question, an arrest. An arrested person has a right to consult a legal practitioner of his choice. The consultation with the lawyer may not be in the presence of the police officer, may be in the presence of the police officer, but not within his hearing. So here option D is correct. So both A and B. Next question, which of the following pairs are correctly matched? These are my favorite questions. Let's form of summon. So form of summon is given in 63. Summons how served. So it is given in 64. Service of summons on a corporate, bodies, firms and societies, it is given in 65. Service when person summons cannot be found, so it is given in 66. Next question, which of the following pairs are correctly matched? Procedure when service of summon cannot be effected before as provided, so it is given in 67. Service on government servant, so it is given in 68. Service of someone outside of local limits, so it is given in 69. Proof of service in such cases and when serving officer is not present, so it is given in section 70. Next question, which of the following pairs are correctly matched? Service of someone on witness, so it is given in 71. Form of warrant of arrest and duration, it is given in 72. Power to direct security to be taken, 73. Warrants to whom directed, 74. Next question, which of the following pairs are correctly matched? So here warrant may be directed to any person, so it is given in 75. Warrant directed to police officer, it is given in 76. Notification of substance of warrant, so it is given in 77. Person arrested to be brought before court without delay, so it is given in 78. Person arrested to be brought before court without delay is given in 78. 24 hours within. Which of the following pairs are correctly matched? Where warrant may be executed, it is given in 79. Warrant forwarded for execution outside jurisdiction is given in 80. Section 80. Warrant forwarded for execution outside jurisdiction is given in section 80. Warrant directed to police officer for execution outside jurisdiction is given in 81. Procedure on arrest of a person against whom warrant is issued is given in 82. Next question, which of the following pairs are correctly matched? So attachment of a property of a person absconding is given in 83. 85. Proclamation of a person absconding is given 84. Identification and attachment of a property of a proclaimed person is given in 86. Procedure by magistrate before whom such person arrested is given 83. Next question, which of the following pairs are correctly matched? So release, sale and restoration of attached property is given in 88. Second point, claims and objections to attachment is given in 87. appeal from order rejecting application or application for restoration of attachment property is given in 89. Issue of warrant in lieu of or in addition to the summons is given in 90. So here option A is correct. Which of the following pairs are correctly matched? Arrest on breach of bond or bail bond for appearances. So it is 92. Power to take bond or bail bond. Power to take bond or bail bond is given in 91. Procedure as to letters is given in 95. Summons to produce documents is given in 94. So option A is correct. Let's go to next part. So next question is, a search warrant is written authority given to a police officer or any other person for search of any place is generally as well as specified things of or document is generally as well as for specified things or documents. Next question, section 94 of Bnss only applies to, so option D is correct, it is applicable on any person to produce a document by court summon. Next question, under section 94 Bnss, a person who is summoned to produce a document on appearance before the court, so option B is correct, does not become a witness and cannot be subjected to cross examination. So next question, which of the following is true for section 94 of Bnss? So 94 of Bnss, it applies to the accused person on trial. 94, option A is correct. Next question, a person who is required merely to produce a documents things under section 94 of Bnss. Option C is correct, either attend personally or cause document things produced in the court. Next question, section 95 of Bnss lays down the procedure for, option A is correct, for production of documents in the custody of postal and or telegraph authority. Section 330, question number 355, where person summoned to produce a document things under section 94 Bnss fails to attend personally or cause the document things produced in the court against such person. So a search warrant can be issued under section 96 of Bnss. A prosecution for an offence under section 210 of Bnss can be launched. So here option D is correct. So A and B both are correct. Next question, in the prosecution for an offence under section 210 of Bnss for non-compliance, disobedience of the summon issued under 94 of Bnss. Options are, an accused cannot take the defense that the document things ordered to be produced is not necessary or desirable for the investigation, inquiry or trial. Next option, the accused can take the defense that the document things order to be produced is not necessary or desirable for the investigation or trial. So next option, the accused cannot question the necessity or desirability of document things in order to be produced for the investigation, inquiry or trial. Next option, that accused cannot be permitted to take the defense that the document things in order to be produced is not necessary or desirable for the investigation, inquiry, trial, as the necessity or desirability already stand adjudged before the issuance of someone to produce the document things. So option B is correct. Next question, as per the section 96 of Bnss, as per the 96 of Bnss, options are search and seizure pursuant to a warrant under section 96 obtained during an investigation is nothing but an integral step in an investigation is true. Next option, it comprehends a situation where a search warrant can be issued as the court is unaware not only of the person but even the place where the documents may be found and a general search is necessary. It is also true. Next option, one cannot cut down the power of the court under section 96 1c of Bnss by importing into it some of the requirement of section 96 1b of Bnss. So here option D is correct. All of the above are correct. Next question, a search warrant can be issued in respect of a place used for deposit and sale of a stolen property, used for deposit and sale and production of counterfeit coin, currency notes and stamps, used for deposit, sale and production of the forged documents and false seals. Here all options are correct, so option D is correct. Next question, in which of the following case a search warrant can be issued? Options are where a court has reason to believe that a person summoned to produce a document or thing will not produce it. Next option, where the document or thing is not known to be possession of any person. Next options, where a general inspection or search is necessary, or all of the above. So here option D is correct, all of the above. Question number 360. Section 102 of Bnss applies to search warrant issued under section 96 of Bnss and section 100 of Bnss, section 97 of Bnss and section 98 of Bnss. So here option A and B both are correct, so option D is correct. Which of the following section gives the power to issue a warrant in lieu of or in addition to a summon and under which condition it applies? So it applies under section 90 of Bnss. First, the court believes that a person summoned has absconded or will fail to turn up. Second, where he has without reasonable cause failed to appear. Next question, who can issue search warrant in respect of postal or telegraph authority? So district magistrate or CJM will be authorized. Next question, who among the following is authorized to issue a warrant to search for a document, parcel or other thing in the custody of the postal or telegraph authority? So here options are chief judicial magistrate, executive magistrate, judicial magistrate or district magistrate. So here options are 1 or 4. So CJM and district magistrate are, so here option D is correct. 1 and 4. Any property which may be alleged or suspected to have been stolen can be seized by police officer. So option B is correct. A court may issue a search warrant. So options are where such document is not known to the court to be in possession of any person, where the court considers that the person of an inquiry or trial of other proceedings will be served by general search or inspection, where the court has reason to believe that a person upon requisition will not or would not produce the document. So here all options are correct. So option D is correct. Who can issue search warrant to search a post office or district magistrate is authorized. Next question. In which of the following cases a search warrant can be issued? A search warrant can be issued where court has reason to believe that the person summoned to produce a document or thing will not produce it. Next option, where the document or thing is not known to be in the possession of any person, where general inspection of search is where a general inspection or search is necessary. So here all options are correct. So option D is correct. Next question. Indicate the correct statement regarding the rights of an arrestee. A person arrested without warrant has the right to points are given to be informed of the particulars of the offence for which he is arrested. It is the correct. Have a relative or friend named by him to be informed about his arrest. It is also correct. Have an advocate of his choice remain present throughout the interrogation. It is also correct. Be medically examined by a medic. Also all options are correct. Option A, B, C, D all are correct. Next question. What is the objective of section 103 of Bnss? So objective of section 103 of Bnss, it provides for the right of free ingress in case of closed premises on demands and production of the warrant of search by the police officer. Next option, it seeks to ensure that the searches are conducted fairly and squarely and that there is no planting of articles by the police officer. So option D is correct, both A and B. Next question. What is the difference between 97 of Bnss and 100 of the Bnss? So the difference is section 90, option B is correct. Firstly, section 97 of Bnss prescribe territorial limitations with regard to search of places suspected to contain stolen property and forged documents, but the section 100 prescribes for the search for wrongfully confined. Remember, 97 prescribes for territorial limitations, where 100 prescribes for wrongfully confined persons. Next question. Under section 98 of the Bnss, certain publications can be forfeited and search warrant can be issued for the same. In this context, the prepositions are, so first point, a newspaper cannot be forfeited and search warrant cannot be issued for the same, as it would be violative of the fundamental right of speech and expression and involves the fourth estate. Second point, a book can be forfeited and search warrant can be issued for the same. Third point, a document can be forfeited and search warrant can be issued for the same. So here B and C are correct. So option C is correct. Next question. A declaration of forfeiture under section 98 of Bnss can be set aside by High Court. High Court has power to set aside a declaration of forfeiture under 98. Next question. The period of limitation for an application to set aside the declaration of forfeiture by the High Court has been provided So options are under 95, under 96, under 97, under 98, and the same is 1 month from the date of publication of declaration, 2 months from the date of publication of the declaration, 3 months or 6 months. So option are 2 months. Next question is, during the investigation a search can be conducted without warrant by, option B is correct, without investigation, without warrant by investigating officer. Next question, search without warrant can be conducted under section 108 of Bnss in the presence of magistrate who is competent to issue search warrant in respect of any place. So next question is, search warrant in respect of police includes search of a person in or about the place only if such person is suspected of concealing about his person any article for which search is being made. Next question, joining of two or more independent and respectable inhabitants of the localities in which the place is to be searched is mandated under section 103 clause 4 of the Bnss. Where the magistrate not empowered by law to issue search warrant for a place suspected to contain stolen property erroneously issues a search warrant. So options are, a search proceeding shall be void and liable to set aside the search. Next option, the search proceedings shall not be void and not liable to be set aside. Next option is, the search proceedings shall be set aside only if challenged by any person aggrieved by the search. So here either option A or option C is correct. So option D is correct. A search proceeding shall be void and liable to be set aside if challenged by any person aggrieved. Next question, section 96(3) of Bnss provides that the magistrate other than the district magistrate or chief judicial magistrate shall issue a search warrant for a document, parcel or other thing in the custody of a postal and telegraph authority if any magistrate not so specified issues such a warrant. So the search proceeding shall be void. So next question is, when does section 100 of Bnss comes into operation? So 100, when the person is wrongfully confined. Next question, section 102 of Bnss applies to search warrant issued under Next question, section 102 of Bnss applies to search warrant issued under section 96 of Bnss and section 100 of the Bnss. Next question, which of the following will lead to setting aside of conviction as well as sentence under provision of Bnss? Options are, when the accused was charged of various offences including section 101 of the Bnss but no specific and separate charges under section 101 was made, but he was convicted under the section. Next option, when the accused was charged under section 101 of the Bnss and the charges could not be proved, but the ingredients of section 106 of Bnss were found, established, and he was accordingly convicted through no charges had been framed under that section. Next option, in a case under section 161 of Bnss where the accused, a public servant, was prosecuted for taking bribe and the charges there was omission to indicate the other public servant with whom service or disservice would be rendered. So option D, all of the above. So correct option is option A, that when the accused was charged of the various offences including section 101 of Bnss but not as specific and separate charges under section 101 was made, but he was convicted under that section. Next question. Section 101 of Bnss enables the magistrate concerned to act in which of the following manner? So abduction or unlawful detention of women or any unlawful purpose, abduction of unlawful detention of a female child under the age of 18 years or any unlawful purposes. So both A and B are correct. So option D is correct. Next question is, in order to achieve the object of section 103 of Bnss, the law makes which of the following obligatory? At least two independent and respectable witnesses of the locality should be present. Correct. The search should be made in their presence and the list of the things used in search should be assigned by them. It is also correct. Document of the place searched or his representative should be permitted to attend during the search and to have the copy of the list prepared. It is also correct. So option D is correct. All of the above. Next question, power to restore possession of immovable property is provisioned under it is provisioned under 106 of the Bnss. Next question, attachment, forfeiture or restoration of property is provided in section dash of Bnss. So it is provided under 107 of Bnss. Attachment, forfeiture or restoration of property. Let's study some case laws. Next question. The principle that accused cannot be stage of framing charges invokes section 203 CRPC. Now section 226 of Bnss 2023 was laid down in option D, Adalat Prasad versus Rootlal Jindal. Next question, in which case the Supreme Court held that the term person does not include an accused person on trial. So here option C is correct, Shyamlal versus State of Gujarat. Next question, which of the following pairs are correctly matched? So first, search of a place suspected to contain stolen property, forged document, etc. It is given in 97. When search warrant may be issued is given in 96. Power to declare certain publications forfeited and to produce and to issue a search warrant for same is given in 98. Application to High Court to set aside declaration for forfeiture is given 99. So next question is, which of the following pairs are correctly matched? Search of a person is wrongfully confined is given in 100 is given in section 100. Next, power to compel restoration of abducted females is given in 101. Persons in charge of a closed place to allow search is given in 103. Disposal of things found in search beyond jurisdiction is given in 104. Which of the following pairs are correctly matched? Next question, recording of a search and seizure through audio electronic means is given in 105. Power of police officer to seize certain property is given in 106. Attachment for future restoration of property is given in 107. Magistrate may direct search in his presence is given in 108. So next question is, which of the following pairs are correctly matched? Power to impound document etc. is produced, so it is given in 109. Reciprocal arrangements regarding processes is given in 110. Letter of request to competent authority for investigation in a country of a place outside India is given in 112. A letter or request from a country or place outside to India for an authority for investigation in India is given in 113. So let's begin chapter 4, which is reciprocal arrangements for assistance in certain matters and produced for attachment and forfeiture of property. So next question, letter of request to competent authority for investigation in a country or place outside India is defined in 112. Option B is correct. Letter of request from a country or place outside in India to a court or an authority for investigation in India is defined in under section 113. So option C is correct. Assistance in securing transfer of persons is defined in section 114. Assistance in relation to orders of attachment or property or forfeiture of property is defined in under section 115. Next question, identifying unlawfully acquired property is defined under 116. Forfeiture of property in certain cases under chapter 8 is defined under 120. Fine in lieu of forfeiture under chapter 8 is defined under section 121. Procedure in respect of letter of request is defined under section 123. Management of properties seized or forfeited under chapter 8 is defined under section 118. Notice of forfeiture of property under chapter 8 is defined under section 119. So here we have done up to 402 questions in our series 1000 questions on Bnss. Thank you everyone for watching.